Lim Chi Wee is president of the Malaysian Bar Association, which is worried about the anti-terrorism legislation replacing the Internal Security Act. Lim Chi Wee, welcome to the program.
Thank you, Jim.
A political question first. Given that Najib Razak has been tantalising Malaysians with the prospect of an early election for some months now, when do you think he will actually go to the polls?
Well, of course, I'm merely speculating, but I rather suspect it will be sometime in September, because the next parliamentary sitting after this session will probably be in June, and there are further law reforms that the Honourable Prime Minister has in mind to table in Parliament. That being the case, I think the earliest will probably be sometime in September.
Now to the question of how free and fair the elections, whenever they are held, will be. What concerns does the Bar Council have about the honesty of the forthcoming elections, and what, if anything, do you plan to do about it?
Well, there are really two main concerns about the coming general elections. The first of which is the integrity of the principal electoral roll. There have been a number of complaints about phantom voters, and the greatest reflection of the problem there actually lies in a reported High Court decision, which was an election case tried more than 10 years ago, where the High Court judge actually said that the problem or the extent of phantom voters in Sabah may just be a tip of the iceberg, and that there has to be greater will on the part of the Election Commission to ensure integrity of the electoral roll. Since then, it's been 10 years since then. It has also been a few months after the release of the interim report of our Parliamentary Select Committee into Electoral Reforms. There have not been sufficient concrete steps taken by the Election Commission to ensure that the principal electoral roll is free of phantom voters. The best solution to that really is the Indian model, where the Election Commission there actually goes house to house to ensure that the registered voters on the roll do in fact exist in the address as stated in the roll. The second concern that we have is whether or not the elections, there's a level playing field in the elections. For example, access, equal access to media and so on. These are the two main concerns that the Malaysian Bar have, and what we have been done is really to continue to urge government to put these law reforms in place before the next elections.
And on that question of phantom voters, is there any likelihood at all of the government introducing measures which would give people confidence that the electoral rolls do have integrity? The Prime Minister has demonstrated an intention to want to change and improve the system by firstly establishing a Parliamentary Select Committee into electoral reforms. Unfortunately, both the interim and final reports contain weaknesses. They don't impose certain timelines for some of the recommendations, and they don't go into details or policies on some of the recommendations. So that falls short of the expectations of the public. And the Prime Minister was supposed to have announced the establishment of a Royal Commission of Inquiry into the problem of phantom voters in Sabah. Until now, that has yet to be announced, although at least two cabinet ministers have publicly declared that there was such a decision made at a cabinet level. So the difficulty we now have is that whilst the Prime Minister's intention is sincere, unfortunately the follow-up action doesn't seem to reflect that. Let's turn to another big issue. The communist insurgency in Malaya ended half a century ago. Why then has it taken the government so long to repeal the Internal Security Act, which was designed to meet the challenges of the emergency?
The ISA was introduced in Malaya then on the 1st of August 1960. Since then, almost 5,000 individuals were detained under the ISA, and subject to official correction, none of whom were actually prosecuted under the legislation. And I think once a government has been so used to such wide powers, it's always difficult to let go. And of course, the government recently in Parliament has acknowledged that, officially acknowledged that this oppressive legislation has been abused. It has now taken this Prime Minister, present Prime Minister, some time to announce for his repeal, and he did so on Malaysia Day last year.
What about the anti-terrorism legislation replacing the ISA? Why do you think it is too draconian?
The Security Offences Special Measures Bill has two marked improvements over the old legislation. The first of which is that we've now done away with indefinite preventive detention without trial laws, in that any individual who's arrested and detained, suspected of any offences relating to security offences, are detained for the first 24 hours, after which it can be extended to 28 days, after which he's either prosecuted or he's released. Second of which is that in the new legislation, there is no what is called ouster clauses, in that there is any act of the police can be subject to legal challenge in our courts. So those are the two improvements in the new legislation. But the weaknesses really centre upon the new rules of evidence, which represent a radical departure from the ordinary criminal trial rules, which are namely that the best available evidence be produced subject to cross-examination. What has happened is that the rules of evidence have made it easier for evidence to be admitted, and secondly, there is the introduction of what is called the summary of evidence rules in favour of the public prosecutor.
These provisions do seem to be somewhat similar to those enacted elsewhere in the world in the wake of September 11, 2001. The government says that questions of national security do need to be guaranteed. They do have a point, don't they?
Well, so far as the debate that is going on in Malaysia at the moment, you're certainly correct, Jim. The similar debate took place in Canada, in the UK, and a little bit in Australia. And so far as the government's intention to ensure that national security is secured and protected, it is never easy to find that delicate balance between collective security and individual liberties and freedom. But certainly what we must always bear in mind, that whatever inroads we make into individual liberties, there are the sufficient safeguards there. And these laws and the change in the rules of evidence cannot be a substitute to better police intelligence and investigations.
Lim Chi Wee, thank you very much.
Thank you, Jim.